Interesting case of a bank's CEO being ordered to attend court. This is an Australian case in New South Wales in which an individual had an adverse entry on their credit file. This resulted from being told that their payments that they were required to make had reduced, and as a result of this there was some discrepancy due to the timing of the payments and so on. Ultimately, the amount of money that we're talking about was 44 Australian dollars, which is about £22. And the issue was whether or not the bank could ultimately correct the individual's credit file by suggesting there was no discrepancy, and etc. And the issue was something that came to light because the individual was applying to buy a property she couldn't complete because of the adverse credit entry, and the matter came before the court because the individual was unhappy with the situation, and the court basically said that the conduct of the bank in this particular case was indefensible, and they described the case as rather extraordinary, so much so that in fact one of the judges that the case came in front of turned round to the bank and said that the CEO of the bank had to attend court for the final hearing on the Monday after the weekend in question. And previously the bank had turned round to court and said that they were completely powerless, that the whole thing in terms of correcting the credit file was the gift of the credit reference agency, not the bank. And yet, notwithstanding that position, once the requirement had been made for the CEO of the bank to attend, the matter corrected itself rather quickly indeed, because over the weekend the bank managed to sort the whole thing out, and the court then basically excused the CEO of the bank from turning up. And what the judge, when he decided to require the CEO of the bank to turn up, said is that it was not unknown. Now, that may be the case, but it's certainly not a routine matter by any stretch of the imagination. It's quite rare indeed that the court will order the CEO of a bank to attend. And in fact, the only thing I can recall that's particularly similar, even though it's not the same as this at all, was there was a case in the UK some years ago when a judge who used to be known as Mr. Justice Peter Smith had some issue with his luggage on a British Airways related ticket, even though British Airways wasn't necessarily the carrier or the airline that was doing the carrying at that particular point in time. And I think the luggage may have gone missing, and the judge was hearing a case involving British Airways, and then basically he wanted some answers to the questions from British Airways barrister, and when some of the answers were not perhaps tremendously forthcoming, the barrister was basically informed by the judge, or the suggestion was made by the judge of, do you want me to order the CEO of British Airways to turn up in the court, which didn't happen. But other than that, I don't think there's that many instances where the suggestion of a CEO of a major commercial organisation, typically would be ordered to attend court. But this was such an example, and fortunately for the individual concerned, everything got sorted out. But the matter is ongoing because there are other issues, potentially things like costs and damages and so on and so forth. But really quite extraordinary given the fact that we're talking about the sum of 44 Australian dollars. Questions, queries, concerns, give us a shout. We know insolvency inside out.